We're going to continue with the part 2 of the course on the new or emerging global order after the end of the Cold War. We've spent 2 lectures on democracy and particularly the enormous promise that democracy seemed to offer, which was sort of for which the South African transition was something of a poster child in 1994. This was, after all, before the mixed legacy of the South African transition, and particularly the failure to achieve much for transformation in the economy that would play itself out in later years. In 1994, it was really seen as the poster child for this democracy that was sweeping the world, including in places where it had not been anticipated. Today we're going to be talking about the International Criminal Court and the responsibility to protect, 2 doctrines that began a fundamental reshaping of the international legal and political orders, and that's going to really consume us for the next several weeks, next several lectures, I should say. Anyone know what this is a picture of? Who are these people? It's Rwanda, yeah. Who are these people? Hutu, what are they doing? How do you know? What are they doing? They're going along with sticks. And who are these people? UN, yeah, these are UN peacekeepers. What are they doing? Nothing. So they're watching. So this is a famous photograph that appeared in The Guardian on the 12th of April, 1994, and did the 1994 equivalent of going viral. Of course, the rules of engagement for UN peacekeeping troops was that they could not become involved in ongoing conflicts, and so in effect they were not in a position to do anything about it. And so this is, you could call a subtitle for today's lecture, Rwanda's Shadow, because this was a horrific genocide in the course of which, in about 3 months, somewhere between 800,000 and 1 million Tutsi were, mostly Tutsi, some moderate Hutu and some other groups, were slaughtered, and in the most graphic, and much of it appeared in the Western media. You can go up, and if you try and look on YouTube, you'll have to sign in confirming your age, because a lot of it is so gruesome. And so the thought was that the international community had to be able to respond. You know, after World War II, we heard these phrases like "never again." This was a clear case of genocide, and if the international community couldn't do things to stop it, it was likely to proliferate. Genocides were likely to proliferate. What I had taught you earlier about the sort of frozen in place international structure of the Cold War was gone, and it was not clear that the major powers would police their surrogates in ways that would prevent this kind of violence. It's really quite a dramatic counterpoint when you think that the very same month, 2,300 miles to the south, the South Africans were having their first democratic election, 3 days of peaceful voting, again, all this euphoria, while at the same time this carnage was going on in Rwanda. Let's listen to President Clinton on the 22nd of July, just after it was more or less over.
morning. I have just met with my national security team. The flow of refugees across Rwanda's borders has now created what could be the world's worst humanitarian crisis in a generation. It is a disaster born of brutal violence, and according to experts now on site, it is now claiming one life every minute. Today, I am announcing an immediate and massive increase in our response. We will provide personnel and equipment to enable these airfields to operate on a 24-hour basis. Our aim is to move food, medicine, and other supplies to those in need as quickly as possible. I've directed the Pentagon to establish a safe water supply and to distribute as much water as possible to those at risk. Safe water is essential to stop the outbreak of cholera and other diseases that threaten the refugees. I've ordered the State Department and our ambassador to the United Nations, who is here with us today, to take immediate action to help create those conditions. The United States will support and urge the immediate deployment of a full contingent of United Nations peacekeepers to Rwanda to provide security for the return of the refugees. We are making clear to the new leaders of Rwanda that international acceptance, including American recognition, depends upon the establishment of a broad-based government, the rule of law, and efforts at national reconciliation. We're taking action to counteract the propaganda of the extremist Hutu elements who continue to urge Rwandans to flee. Taken together, these steps will help to relieve the suffering of the Rwandan refugees and create conditions for their return home.
So, President Clinton was heavily criticized after that speech, and the reason he was heavily criticized was not for what he said, but for what he didn't say, and indeed for what the administration had systematically been refusing to say throughout the buildup and then the unfolding of the Rwandan crisis. That was the word genocide. He refused to say genocide. And you can now find in the archival documents, there was a lot of back and forth in the administration where huge resistance to using the word genocide on the grounds that would dictate that we would have to go and do something. And President Clinton was extremely reluctant to do anything, to get American troops involved in this conflict, because he had had his nose badly bloodied 6 months earlier in Somalia, in the so-called Battle of Mogadishu. And so the U.S. this had started under the Bush senior administration. The U.S. had been the leading player in the UN's peacekeeping operation in Somalia, called the UN Operation in Somalia. And it was an ongoing civil war, and as part of that effort in what was widely seen as a badly botched American operation, 2 Black Hawk helicopters had been shot down, and the so-called Battle of Mogadishu proceeded, in which 18 Americans were eventually killed and 73 wounded. And from the point of view of the administration, what was especially damaging was 3 dead Americans were dead or dying Americans were dragged through the streets of Mogadishu and filmed being so dragged. And this was again, a 1990s version of going viral. It was seen as huge incompetence on the part of the American administration. Probably the most damaging thing for Clinton, at least the most damaging thing for an American president, at least since Jimmy Carter's botched operation to free the hostages in Tehran in 1979, when we also had helicopters coming down in the desert. And in fact, in the 18 Americans killed in the Battle of Mogadishu was the largest number of U.S. fatalities since the Vietnam War. So it was seen as a really big deal that would eventually be surpassed in the second Battle of Fallujah that I talked to you about some time ago, where some multiple of that was killed. I think about 95 American soldiers were killed in that battle. But at the time, this was seen as a horrific mess that the U.S. had gotten into, and the Clinton administration had responded by deciding to get out of Somalia rapidly. And so they pushed the UN essentially to declare the end of the Somalia operation the following year, and they were in the midst of withdrawing from that. So the last thing the Clinton administration wanted to do was get American troops involved in another civil war where they could have taken a massive domestic political hit. And so it's not surprising, even if it's not impressive, that President Clinton refused, and the administration refused to call what was going on in Rwanda genocide, and refused to get involved until the conflict was, for all practical purposes, over. So today's agenda is we're going to look at non-intervention, this idea that has to be broached if we're going to start talking about protection of international human rights in the post-Cold War world. We'll dig into what the ICC and the doctrine of responsibility to protect are, how they came to be adopted, and what force they have in the world. We'll ask the question how radical a reshaping this is of the international political and legal order. And they're both very much doctrines in evolution and in flux. So to some extent we're looking at moving targets, but we will do the best that we can. And as we go through, I want us to pay particular attention to our three I words, to the role of ideas and ideals on the one hand, of institutions. We're talking about changing institutions. Secondly, and thirdly, the role of interests and how they play out as these ideas and institutions come under pressure to be reshaped. And the place you have to start, if you're thinking about the international protection of human rights, is the strong presumption against intervention in another country by external players. And this hasn't always been there. In fact, if you read my colleague Ona Hathaway and Scott Shapiro's book in the law school, they will tell you, and they are right about this, that the idea that national sovereignty is completely inviolable doesn't become fully entrenched in international law until the UN Charter is adopted after World War II. And the UN Charter was centrally about preventing the invasion of one country by another and preserving, in that sense, the nation-state status quo in the world after World War II. And so the idea, the norm that no nation can intervene in the activities of any other nation becomes enshrined in the UN Charter and almost is part of its raison d'etre. Because what we need to remember when we talk about the UN, talked about this briefly at the beginning of the course, but the purpose of the UN was not to be a world government. The purpose of the UN, first and foremost, was to prevent another war between the major powers. This is why it was structured in the way it was, and this is why the Security Council, which is the closest thing to the executive body of the UN, is structured the way it was, with the 5 victorious dominant powers at the end of World War II having a veto over anything that the Security Council did. And the notion was that it would be better to force them to cooperate by having to agree before any international action could be taken. And when international action was taken, the default presumption was that the term of art was to restore international peace and security. And the idea of restoring international peace and security was to stop wars, to stop invasions, to stop anybody from trying to grab real estate in the world. Of course, it came to take on many other roles, but that was the initial purpose of the UN. It's why it was structured the way it was. And we should also remember that it was basically a creature of a treaty, a multilateral treaty. In this sense, its basic structure is like the basic structure of the EU. Even though we saw with the EU, there were efforts around the time of Maastricht to make the European Union, the parliament elected by the citizens of Europe, sovereign. That didn't work, and by the time we got to the Lisbon Treaty, there was the Lisbon Round, there was basically modification of this treaty-based structure. So the UN is based on a treaty. And that, of course, means if you want to change it, you'd have to negotiate a new treaty, at least in principle. And the treaty created this structure whose initial raison d'etre was to prevent war, and certainly to prevent war between the major powers. So a big part of the question, given that the UN is the sort of presumptive international institution in the world today, is can the structure of the UN be changed, and if so, how? And what's interesting about the ICC, and particularly the doctrine of responsibility to protect, is we might characterize them as sort of common law efforts, or quasi-common law efforts, to change the basic structure of the UN, to make it operate as more of an authorizer for intervention, in much more radical intervention in the case of R2P than in the ICC, but nonetheless, to make it possible for this idea that nobody intervenes in the activities of any country to start to be questioned. So let's talk about the ICC first. If you think about the idea of holding war criminals to account for their crimes, previously there had been talk going back all the way to 1919 of the idea that there should be some kind of international criminal court. Came up again at the end of World War II. But if you look at what was actually done, we had previous tribunals were all ad hoc tribunals. So we had the International Military Tribunal, commonly known as the Nuremberg trials after World War II, the International Military Tribunal for the Far East, less well known, but the Tokyo trials for Japanese war criminals. We had the Eichmann trial in 1961, I believe it was, in Jerusalem, where Israel captured Adolf Eichmann and brought him in Argentina, and brought him and tried him and executed him in Jerusalem. And then we had in 1993, the International Criminal Tribunal for the former Yugoslavia, again an ad hoc, this time created by the UN for the first time, tribunal to try war criminals from the Yugoslav conflict, and then the International Criminal Tribunal for Rwanda that was created after the Rwandan genocide to try criminals for the Rwandan during the Rwandan genocide. So they were ad hoc. The last two, you see UN action. Before that is essentially victor's justice. It was often criticized as being, and certainly by people on the other end of it, when the winning powers in conflicts held trials of people from the defeated side. So there was no international body that could engage in these kinds of trials. The International Criminal Court was initiated by the Rome Treaty, which was signed by 120 countries in July of 1998, and finally ratified by 60 of them in 2002. It has a strange relationship toward the UN, because the structure of the UN was such, as I said to you, they couldn't create a court without going back to the signatories of the treaty. But they had a strong interest, they thought, or many people at the UN had a strong interest in trying to create some sort of permanent international legal tribunal. And so they commissioned a group of lawyers called the International Legal Council, International Legal Committee. I can't remember the exact title, but these are experts in international law appointed by the UN General Assembly, and they asked them to draft a statute that could become the basis for an international criminal court. And they did indeed do that. And the UN General Assembly sponsored multiple debates of this statute and eventually a conference which led to the Rome Treaty. And the UN General Assembly was by no means alone. A variety of NGOs were involved in this as well, NGOs pushing for the creation of norms that would change international law so that perpetrators of war crimes could be held to account. It came into operation in July of 2002 when 60 states had signed it. And today there are 129 states are now signatories of the multilateral treaty that creates the ICC. So it's independent of the UN, technically, and it's a separate treaty that is the foundation document, the statute that creates this treaty, this institution. It can prosecute, originally it was war crimes, crimes against humanity, and genocide, and a crime of aggression was added in 2010. It has a pretty broad jurisdiction in that it can prosecute crimes in any of that occur in any of the signatory countries, or crimes that are perpetrated by citizens of any of the signatory countries. Generally speaking, crimes are referred for prosecution by the countries themselves, perhaps after a transition. For example, when there's limited ability of the existing legal order to go after people, perhaps because they are not there anymore, or for perhaps because the country's in a civil war, doesn't have developed judicial capacities. This is not the only way that they get crimes referred to them, but it has 18 judges who are elected by something called the Assembly of State Parties, which are the signatories to the treaty, and they sit in 3 different chambers. One does groups of 3 judges, one does pretrial hearings, one does the trials, and one does the appellate work. I say it's a parallel but sort of independent institution in that actually the UN Security Council has begun to refer cases to the ICC. This happened after Darfur when the Security Council referred some cases there. And once a case is referred, there's a prosecutor for the ICC who does a preliminary investigation to see whether charges should be brought. And then in 2011, in the Somalia, in the Darfur referral, the U.S. and China abstained. And this was partly because the U.S. and China are not signatories to the ICC for reasons I'll get to in a minute. But in 2011, the Security Council unanimously referred Gaddafi for prosecution by the ICC. And as Mark Mazawa comments in the chapter that I had you read for today, this is part of what has provoked a lot of commentary about the hypocritical attitude of the U.S. toward the UCC, because on the one hand we have not signed the treaty and we refuse to be subject to its jurisdiction, and indeed in peacekeeping operations, if the Security Council authorizes peacekeeping operations, the Americans require that their soldiers cannot be subject to the jurisdiction of the ICC as conditions for participating in peacekeeping operations. So it's not a legal system to which the U.S. will submit. On the other hand, here they're participating in referring others to the Security Council, most dramatically Gaddafi in 2011. So how important is this institution? As of 2019, it had handed down 44 indictments. It had arrested, it had issued 36 arrest warrants. It had 23 ongoing proceedings. There were 15 fugitives at large who had arrest warrants out for them. 21 proceedings had been completed. So this is from 2002 to 2019. So in 17 years, 6 people had been convicted, 4 had served prison terms and been released, 2 were still serving them. The rest had been acquitted, charges had been dismissed, charges had been withdrawn or otherwise fallen apart, and 4 people had died before trial. So, tiny numbers, you might say. How should we then think about it and its legitimacy? Well, one thing to say about it is that it's long been criticized, particularly in the Global South, as heavily biased against African countries. All the convictions to date have been of people in African countries, and virtually all the prosecutions. There's a very good not every Wikipedia page is good, but there's a very good Wikipedia page which gives a running account of all the prosecutions currently ongoing, and it stays up to date. And the sense that it was anti-African became a source of a lot of criticism of it. And indeed, even today, although prosecutions have been opened, one in Myanmar and one in Georgia, but the vast majority of them are African countries. And in 2016, Burundi, South Africa, and Gambia all said that they were going to leave. There was then an election in Gambia that reversed that decision after the new government came to power. In South Africa, interestingly enough, it was the Zuma government that said they were leaving, but the South African Constitutional Court ruled that it would be illegal for South Africa, it would be unconstitutional for South Africa to leave, so they rescinded their decision to leave. But the Philippines, after Duarte's anti-drug efforts, where people are very violent anti-drug campaign there, were referrals to the ICC for prosecutions in the Philippines. The government announced that they were leaving, and they left. It takes a year to leave, and incidentally does not immunize a country from prosecution for during the period when they were members of the ICC. So it doesn't mean that in principle the crimes committed in the Philippines couldn't still be adjudicated. Israel, Sudan, the US and Russia have all withdrawn their signatures from the treaty, and the US role over time bears some attention given that we're now in a unipolar world and the American role is so important. So the last possible day you could sign the treaty creating the ICC was the last day of the century, and the last day of the Clinton, not quite the last day of the Clinton administration, it ended the following January, and the Clinton administration signed it. But you can see from what President Clinton said, he said, "We reaffirm our strong support for international accountability and for bringing to justice perpetrators of genocide, war crimes, and crimes against humanity. We do so as well because we wish to remain engaged in making the ICC an instrument of impartial and effective justice in years to come. So they were signaling they didn't like it, but they were going to remain engaged and essentially punt this question to the next administration. They're going to punt the question to the incoming Bush administration, but they didn't want to forestall the possibility of the U.S. being involved. The Bush administration came in to office, as we all now know, a year shortly thereafter. We had 9/11. The Bush administration before that had taken no action to move forward with American involvement in the ICC. After 9/11 in 2002, the Bush administration withdrew America's signature, and so that was the end of that as far as the ICC was concerned. When the Obama administration came in 2009, they took a somewhat softer attitude toward this ICC and began to engage with it and cooperate with it in various investigations and have observer status at meetings about it and of some of its organ bodies. But even the Obama administration showed no interest in actually having the U.S. sign, partly for the same reason that I'd already mentioned, which was the idea that the U.S. Involvement in peacekeeping operations would lead Americans to be vulnerable to prosecution was not something that the administration thought it could sell to the American voters. Of course, since then we've had the Trump administration, and as you might surmise, that hasn't produced any change either.
The United States will provide no support and recognition to the International Criminal Court. As far as America is concerned, the ICC has no jurisdiction, no legitimacy, and no authority. The ICC claims near universal jurisdiction over the citizens of every country, violating all principles of justice, fairness, and due process. We will never surrender America's sovereignty to an unelected, unaccountable global bureaucracy.
So there you have an unsurprising summation of the American attitude and reaffirmation of the idea that international law applied to American citizens is not going to be acceptable. So how should we think about whether the ICC is a good or bad thing? Any thoughts about that? Anyone think it's a good thing? Good thing. Somebody who thinks it's a good thing. Yeah.
A metric would be the number of people who are killed in interstate conflict.
So you say that it would be whether it's a deterrent or not?
Yes.
Okay, one metric, would it be a deterrent? Yeah. And what else? Anyone else? So you're just saying that's the metric. You're not sure whether it's a good or bad thing. You think it's a good thing? Why is it somebody who thinks it's a good thing, why is it a good thing? Yes, sir.
I think it provides an infrastructure for countries who have gone through particular bad situations, war crimes, genocides, to have access to an institution that is, judicial in its form when otherwise it wouldn't have it.
Any other thoughts? Anyone else think it's a good thing? Yes, sir. I see one hand here.
Thank you. So I think it's not effective, in fact, but it's a good symbol in the world.
It's a good symbol.
Yes.
What, a symbol of what exactly?
To show the accountability of those
that people can be held accountable for what they do. That dictators or people engaged in wars there's some chance you might be held accountable. It stands for that idea. So, okay, anyone think it's a bad thing? The truth is it's tricky to evaluate. So the small scale might not matter that much because, you know, the question is not whether it's small, but perhaps whether it's scalable. And there's a literature in political science for which Martha Finnemore and Catherine Sickink are famous, where they talk about norm cascades. And the idea is that once a norm starts to get established, provided a critical number, and scholars argue about how many, endorse the norm, others join up as well. And interestingly, on that front, in 2016, when South Africa and Gambia and these others were threatening to storm out, there were a lot of predictions that it was all going to fall apart and that there was going to be a massive African exodus. That didn't happen. So to the extent that, you know, they also talk about norm entrepreneurs, people who are trying to, this is the realm of ideas now, of our three I words, that norm entrepreneurs are trying to get enough countries to start investing in a process that you then reach this tipping point where it will start to become embedded, it might become scalable, and so on. The deterrent effect obviously is very tricky to evaluate in the sense that at the level of what lawyers call specific deterrence, that's deterring actual individuals from committing crimes, most people, this is sort of parallel to the debates about the death penalty in the US, most people who murder people are not deterred by the death penalty because the point of murdering someone is a point, first of all, nobody's thinking about being apprehended, and it's usually seething hatred, passion, etc. And so it's not clear it has any specific deterrent effect. Whether it would deter others, that's what we call general deterrence, hard to say. I would just point out one thing that nobody has really fully thought through about this doctrine, and this is, think about what my earlier discussion of Hirschman in connection to democratic transitions. I said that one of the things that needs to happen to get dictators to give up power is that the cost of exit must be low, relatively low. Otherwise, they're going to hang on until the end of time. And so, for instance, Idi Amin got to live out his life, ironically, in Libya after he was forced out of power. He had a place where he could go, and he was not prosecuted for anything. Gaddafi, on the other hand, was referred to the ICC. He was killed before he was ever brought to trial. But so if you're thinking about amnesty, amnesty as part of a negotiated settlement for a conflict, how that would square with this doctrine is a difficult thing to think through, and there are obviously trade-offs there. So it's not obvious. It's not obvious how we should think about this doctrine, but it is alive. It is, as it's sort of wobbled into existence. It is subject to all these criticisms. It's inequitably applied. The U.S. in particular has been rather hypocritical in the way that it's used the doctrine that it won't allow itself to be subjected to. But the norm entrepreneurs would argue, this is the way that norms gradually get established and embedded in the international order. And so the goal should be to improve it and to address its defects rather than say that it's just illegitimate way in which some countries beat up others. Let's turn to the responsibility to protect, which is in some ways a much more ambitious rewriting of the international rules. Anyone know what that is? Pardon? Nope. Good, reasonable guess, yeah. Well, it's the NATO bombing of Kosovo in 1999. And the NATO bombing of Kosovo in 1999 came after many years of civil war that had basically broken out with the collapse of the Soviet Union, and Yugoslavia had come to pieces. And there was ethnic cleansing of Albanian Muslim Kosovars at the hands of Serbian militias going on. And the NATO alliance, notice, the NATO alliance took a decision to intervene. Here's President Clinton talking about it.
The Kosovars have been victims of terrible atrocities. Their only hope was that the world would not turn away in the face of ethnic cleansing and killing, that the world would take a stand. We did for 78 days. Because we did, the Kosovars will go home. To achieve our aims as an alliance, 19 democratic nations with 780 million people working together in the first sustained military operation in NATO's history. The alliance did stay together. It is now stronger and more united than ever, and I thank my fellow leaders in the alliance for their fidelity and their fortitude. In the past 4 months, we have seen some of the worst inhumanity in our lifetime, but we've also seen the bravery of our troops, the resolve of our democracy, the decency of our people, and the courage and determination of the people of Kosovo. We now have a moment of hope, thanks to all those qualities, and we have to finish the job and build the peace.
So, what had happened here was that this ongoing civil war had resulted in many human rights violations on all sides. But this was the point at which, when there was this imminent ethnic cleansing in Kosovo, that NATO decided to intervene in mid-1999. And one thing about this intervention was that it was widely judged to have succeeded. That is to say, the ethnic cleansing ended and didn't reinitiate, even though there were no NATO troops on the ground in Kosovo. There were European Union troops massing on the border, some, but they never actually went in. It was very unusual for two reasons. One was that this was a NATO operation, and it was in violation of the NATO Charter. We've talked about NATO. You know that Article 5 authorizes NATO members to use force and indeed to turn to one another to use force if any one of them was attacked. But no NATO member was threatened during the Kosovo and the former Yugoslavia Civil War. There was no threat to any member of NATO. So this was not a legitimate activity for NATO as a defensive alliance to have been engaged in. It was also not authorized by the Security Council. Why was it not authorized by the Security Council? Because the Russians were basically on the sympathetic to the Serbian side in this conflict, and clearly the Russians and almost certainly the Chinese would have vetoed any attempt to get authorization for NATO to get involved in this conflict. So there was no Security Council authorization. And it was not anything that one could legitimately say was part and parcel of NATO's mandate to protect the member states. They just did it. They simply did it. Now, one might say, what were Clinton's motives? And some have said his motives were to divert attention from Monica Lewinsky. Christopher Hitchens, among others, claimed that. But even setting Monica Lewinsky aside, I think part of Clinton's motivation surely was to redeem himself. He had taken so much criticism after Rwanda for the U.S.'s failure to act in the Rwandan controversy, and here he was on the verge of leaving the presidency. This is summer of 1999, and he thought, this is my moment to redeem myself and to show that the U.S. will in fact act. And indeed, he enunciated what some of his hiographers called the Clinton Doctrine. He said here, shortly after that press conference I showed you, he said, never forget, if we can do this here, and if we can say to people of the world, whether you live in Africa or Central Europe or any other place, if somebody comes after innocent civilians and tries to kill them en masse because of their race, their ethnic background, or their religion, and it is within our power to stop it, we will stop it, right? Very different than the stance he took over Rwanda. And the Secretary General of the UN was Kofi Annan, now the Ghanaian Secretary General, now deceased. He got behind this. He said, if humanitarian intervention is indeed an unacceptable assault on sovereignty, how should we respond to a Rwanda, to a Srebrenica, to gross and systematic violations that affect every precept of our common humanity? And his answer was, the sovereignty of states must no longer be used as a shield for gross violations of human rights. This is a dramatic statement in strong tension, to put it mildly, with the Charter of the UN. But the question becomes, how can you do that? How does one do that, particularly given a world of nation states that, whose sovereignty is protected? And so there was a lot of hand-wringing and wrestling with this problem. And interestingly, the Prime Minister of Sweden took it upon himself to appoint a commission on Kosovo, which was established in August of 1999. And the commission reported with the following statement. It said, the commission concludes that the NATO military intervention was illegal but legitimate. It was illegal but legitimate. It was illegal because it did not receive prior approval from the Security Council. However, the Commission considers that the intervention was justified because all diplomatic avenues had been exhausted and because the intervention had the effect of liberating the majority population of Kosovo from a long period of oppression under Serbian rule. Illegal but legitimate. What can that mean? Can we say something is illegal? Yes, you need the microphone. We'll need a dissertation here. Yeah. Wait a second, get the microphone. They'll never hear you otherwise, yeah.
Yeah, I mean, it just seems like it's the international community trying to reconcile the contradiction of that you just put, national sovereignty, but sometime intervention good. This seems like you can't have war or the idea of armed intervention that still respects national sovereignty. And so it seems like this is just a halfway return to the World War II consensus of, well, national sovereignty is a given.
So it certainly is a different conception of national sovereignty, but you're saying it's illegal but legitimate. We can say we can violate international law when it's legitimate for us to do so. But what legitimates the action? How is it legitimate? What makes it legitimate?
Perhaps thinking about the ideas, interests, institutions, it's a matter more of interests, and especially power interests, than institutions in itself?
One more at the back, yeah? Oh, okay. Yes, sir. We'll take two more, you and then you, yeah.
I would just say R2P trumps the international order.
Say that again.
R2P trumps the international order.
Responsibility, well, we don't yet have a doctrine of R2P at this time, right? So we'll have to see, but yeah. Okay, gentleman at the back, the last one, yeah.
The ends that justify the means.
The ends justify the means. So another way of saying that, and perhaps capturing what some others were saying, is perhaps sometimes it's better to ask for forgiveness than permission, right? Sometimes it's better to ask for if you know some horrific thing is about to happen that you can stop, and you also know that if you ask for permission it's going to be denied, maybe you better just do it, right? Maybe you better just do it. And so that, you know, and that moral philosophers have debated this principle, or maybe it's a pragmatic judgment and not a principle, but there's a principle behind it, presumably, which is that some things are so egregiously bad and so frightening that, you know, if the legal order will not permit it, it's too bad at some level for the legal order. And so this was, I think, the thinking behind this idea of illegal but legitimate. But of course, how do you turn a norm like that, how do you turn a dictum like that into a norm, much less a rule? How can you institutionalize the idea of that it's okay to ask for forgiveness rather than permission? Not obvious how you can do that, because the whole idea is you're acting against the existing institutions because you've concluded that it's the right thing to do. So how might one institutionalize that? And it's important to say that not everybody agreed. Not everybody agreed. We say the international community this, the international community that. The international community didn't agree. Not everyone thought that Kosovo should become a precedent, especially in the global south. The logic was seen as a potential smokescreen for major powers to pursue their own agendas. Within months, the G77, this is a large number of developing world countries, condemned the so-called humanitarian intervention. South Africa and India amplified this criticism. Nelson Mandela, who had recently stepped down as South African president, said, when two nations, he wasn't fooled by the idea that it was a large coalition, basically the US and Britain, take it upon themselves to police the world without getting authorization from the UN, we must condemn that because it can lead to another world war. The South African government, reflecting the positions of the non-aligned movement and the OAU, declared unilateral intervention, no matter how noble the pretext, is not acceptable. India called the Kosovo operation a flagrant violation of all international norms against the provisions of the UN Charter and seen as and saw it as a direct and unprovoked aggression. As I said, there wasn't consensus about this by any means across the global south, and particularly because this was a NATO operation led by the US. So that led to was followed by, I shouldn't say led, it wasn't caused, but it was followed by an international commission on intervention in state sovereignty that was convened in London, again with input from the UN and various NGOs, and it was chaired by Gareth Evans, a former Australian Prime Minister, Mohamed Sanoun, who was an Algerian diplomat and a major player in it, was the Canadian academic and sometime not very successful Canadian politician, Michael Ignatieff. And they came up with this idea of the responsibility to protect. And we'll talk in some depth about it in a minute, but I want to note, first of all, that the concept of the responsibility to protect is as important for what it doesn't say as for what it does say. It doesn't say that there's any right. It talks about a responsibility. It doesn't say that there's a right. The responsibility here is not, there's not a responsibility on the UN or on the Security Council. The responsibility, in the phrase responsibility to reflect, refers to governments. Governments have a responsibility to protect not only their citizens, but people living within their territories. It doesn't talk about an obligation to intervene. Even though it suggests there's some kind of imperative for action, it doesn't say when you have certain kinds of rights violation, there's an obligation to intervene. I'll say of this more later. Again, in the Global South, this was not welcomed. And the African Union said, well, if the UN is going to start taking upon itself to authorize intervening in other countries, so are we. And so the African Union asserted the right to intervene in a member state. That's pretty much, I think there's 50 members of the African Union, almost every African country, pursuant to a decision by the Assembly in grave circumstances, namely war crimes, genocide, and crimes against humanity. And notice that there's no mention of the Security Council, despite the fact that the UN Charter reserves to the Security Council a monopoly on declaring non-defensive use of force. So essentially the African Union is saying, well, if the Security Council or NATO or other groups are going to start intervening in countries, then so are we. And so the stability envisaged in the NATO Charter could be seem to be threatened. In 2005, the UN General Assembly debated this so-called World Summit outcome document and adopted it, behaving now as a kind of legislature. That is to say, remember what I said at the beginning of the lecture, that the UN is a creature of a treaty. It is the General Assembly is not a legislature. But in any case, they adopted this provision, and they said, each individual state, that country, has the responsibility to protect its populations from genocide, war crimes, ethnic cleansing, and crimes against humanity. These all have complex legal definitions which people wrangle over. This responsibility entails the prevention of such crimes, including their incitement, through appropriate and necessary means. We, this is the UN General Assembly, accept that responsibility and will act within accordance of it. We are prepared to take collective action in a timely and decisive manner through the Security Council on a case-by-case basis and in cooperation with relevant regional organizations as appropriate. Should peaceful means be inadequate and national authorities manifestly fail to protect their populations from genocide, war crimes, ethnic cleansing, and crimes against humanity. So here you have the UN General Assembly taking it upon itself to say there's a responsibility to protect. It falls on governments, and if they don't live up to that responsibility, the Security Council can authorize regional organizations and other players to intervene. That's hugely important because the UN does not really have much of an army, and UN peacekeepers traditionally have only gone into conflicts once there's peace established. As we saw in the very beginning with the Rwanda picture, they did not go into actually to get involved in peacemaking, but only in peacekeeping. So some things to think about with responsibility to protect. First of all, unlike the ICC, it's binding on signatories and non-signatories alike. So they have declared unilaterally that this doctrine is binding on all governments. They restricted it to these four major categories of crimes: genocide, crimes against humanity, war crimes, and ethnic cleansing, even though the Evans-Sanoon Commission had wanted a much more expansive set of things to protect against, but the thinking was that in order to get a majority to accept it, it would have to remain focused on the most egregious violations. The domestic focus here seems and indeed does contradict the UN Charter's focus on international peace and security, because now, in effect, what R2P has said is that it is legitimate for the international community as represented by the United Nations and authorized by the Security Council to intervene in the domestic affairs of a country if it's triggered by one of those genocide, crimes against humanity, war crimes, or ethnic cleansing. Another feature of it that's worth noting, and this again goes to my earlier observation that there's no right to demand intervention. It's not binding on the Security Council to intervene. As I said, it gives wide latitude as to when the Security Council will be intervening, because it intervenes on a case-by-case basis. So the Security Council may intervene, but there's nothing in this doctrine which says the Security Council must intervene in any particular conflict. And that will turn out to be important. The non-aligned movement didn't like it. And the non-aligned movement is a group of mostly middle-income countries around the world. So how should we think about this doctrine? This is obviously, as I said, both the ICC and the responsibility to protect are starting to rewrite the international architecture of intervention. But this is a much more ambitious rewriting than the ICC. And we're now not talking about prosecuting a few individual perpetrators. We're actually talking about intervening in countries during ongoing conflicts to make peace and stop gross human rights violations. Just a good move? Who thinks it's a good move? Somebody want to? Okay, yes, ma'am. Let's skip.
More norm setting?
So say a little bit more about the norm setting.
I don't know much more, but it seems like it would be a good norm to have for humanity.
Okay, it's certainly a norm. It seems like it's gone beyond a norm now. It's right. This is really changing international institutions, right? We now have the Security Council in a position to actually intervene. This is it is, if you like, a common law, by which I mean a gradual, but nonetheless decisive rewriting of the rules governing UN intervention within the affairs of governments. Doesn't mean it's good or bad, but it's very extensive. Any other? Yes, sir. Wait a second.
I think it's highly contradictory, and any country can, depending on its own utility, can decide whether to consider it as a genocide or not. And I can give two examples. U.S. was highly criticizing the war affairs in Syria, while in Ukraine, when the radicals just burned the opera house in Odessa, it was kind of okay because...
So there may be disagreement as to whether the conditions prevail or not, at least in some cases.
I mean, I think it can be still biased, and depending on the...
It could be manipulated.
Yes.
It could be manipulated, but any doctrine can be manipulated just to play devil's advocate to your comment for a minute. Let's go back to Rwanda in 1994. The fact is, no one had any doubt in Rwanda in 1994 that genocide was going on. It was you know, you can go back now through the archives, and it's perfectly plain that all the major powers knew that genocide was imminent, and then it was starting, and then it went on for many months. Now, they might not have been able to stop it. It might not have been successful, but the book I put on the syllabus, I think, is probably the best book on this. Certainly, the estimates are that of the 800,000 to 1 million people killed, had there been intervention, at least 200,000 people could have been saved. So you could say, well, still be 600,000 killed, yes, but 200,000 people's not a trivial number of people, right, to save. Even if that's double what really could have been, you know, it still would have been. So that would be, that, you know, there might be cases where it's manipulable. There might be cases where it's unclear, where it's disputed, and we'll talk about one of those cases in a few classes, 3 classes from today. Yeah, any other thoughts about whether this is a good way for international law of intervention to evolve? Yeah.
Within the constraint of there being a veto, it's an establishment of some kind of world government as the legitimate user of force, and I would support that.
You like the idea that there's a veto?
No, I like the idea that there's a legitimate use of force in this instance,
Okay.
but it does basically change the Charter of the United Nations.
So
but it has a constraint still that there is a veto, but that is
there's a
constraint that
veto
I'm
in the
willing to
Security
accept.
Council. Yeah, the permanent members, they're now permanent and non-permanent members of the Security Council, but the original 5 still have a veto. Okay, so anyone think it's a bad idea? We'll defer judgment of that question a little while. So here were some early tests of this doctrine. This is actually before the outcome had been adopted by the General Assembly in Sudan. The Security Council called for an arms embargo and referred to the idea. It was still being debated then. In Kenya in 2006, after the election, there was an eruption of ethnic violence. 800 people were killed. More than 250,000 were displaced. And the French called for a responsibility to protect, action to intervene. Kofi Annan headed it off, basically, by going there and negotiating a settlement. And some argued that it was the threat of the possibility of intervention that actually helped him negotiate or mediate the conflict in a way that headed off the violence or damped it down. In Guinea in 2008, there was an attempted coup. The leader, Camara's troops rioted against demonstrators, and by then it was Ban Ki-moon who was Secretary General. He set up an inquiry and raised the possibility of crimes against humanity and started again talking about R2P. The US and EU suspended assistance, but it became moot after Camara fled the country. And so again, they were on the verge of intervening on the grounds that there were gross human rights violations going on, but then they actually didn't. And then in 2011, I mentioned to you earlier that the Security Council unanimously, including the US, referred Gaddafi to the ICC for prosecution. But in the course of that referral, they talked about the responsibility to protect being triggered possibly in Libya. This was in February of 2011. They were hinting already that they might be, this is following the outbreak of the Arab Spring. We've had eruptions in Tunisia and in Egypt, and now in Libya. Civil war breaks out, and there were claims, disputed claims about imminent slaughter in Benghazi, much disputed, and we'll talk about the disputes later. In any event, they referred Gaddafi to the ICC, and they talked about the responsibility to protect and used that to impose an arms embargo on the country and various other sanctions. The first real test of R2P came the following month when the Security Council adopted UN Resolution 1973 authorizing intervention in the Libyan conflict. And we'll return to that on October 24th, and we'll then think about, at the end of that examination, we'll see what we think about the future prospects for the doctrine of responsibility to protect. But first, we need to attend to the global war on terror, which fundamentally changed the international legal and political landscape in ways that affected the prospects for doctrines like the responsibility to protect. And we'll do that starting next time.